Good morning, everyone, and welcome to the latest in our series of legal webinars in conjunction with Carson McDowell. I'm David Fletcher, Chair of CPC-NI. Each of these webinars has been specifically designed for construction professionals. Our talk this morning is titled Construction and Engineering Law 2021 Review. Stuart Murphy, John Dugdale, Rebecca Ferguson, and Gavin Kerr from Carson McDowell's construction team will review the key court decisions from 2021 that impact on construction and engineering projects. The talk will run to around 11:45, at which time we will have a question and answer session. So if you have any questions for the panelists, please drop them in the chat function and we will try to get through as many as possible before we finish at 12 o'clock. We plan to have a fourth webinar in March, so we would invite attendees to put through particular topics that they would like covered in that webinar. So hopefully we can accommodate these suggestions, and if we can drop them through, we'd be grateful. So without further ado, I'll hand over to Stuart to start the talk. Stuart, over to you.
All right, David, thank you very much. And welcome everybody. Thanks for joining us this morning. We're going to try and get through in the next 45 minutes or so some of what we think are the most interesting cases of last year, and have a look at what that might mean for everybody's day-to-day practice going forward. I'm going to start by looking at a couple of cases, one relating to getting your payment notices correct and what that might involve, and a second one about collateral warranties, and in particular whether or not adjudication under a collateral warranty is now an option. And those are the two cases there that I'm going to talk about briefly, both decided in the Technology and Construction Court last year. So let's start with payment notices. And just by way of a bit of a reminder of what the requirements are in relation to payment notices, under the Construction Contracts Order, hopefully you'll all be aware that in relation to every payment under a construction contract, the payer is required generally to give a payment notice not later than 5 days after the payment due date. That's not one of the periods that the parties have the liberty to amend. The 5-day period is a payment stipulated by the order itself. And in giving a payment notice, the order requires that the notice must state the sum that the payer considers to be or to have been due at the payment due date, and also the basis upon which that sum is calculated. And why all of this is important is that, as I'm sure you'll know, if you fail to serve a valid payment notice on time, then, and you're the paying party, you expose yourself to what's become known as a smash and grab approach, and the amount that the payee may have applied for might become the sum that you're required to pay if you don't serve a valid payment notice on time. So the case I wanted to look at this morning is this Downs Road case. And the facts of it are, if perhaps slightly unusual, they are relatively straightforward. It was a JCT Design and Build 2011 contract, fairly standard, for the construction of 79 residential units. And the approach that the employer, the payer, took to the payment cycles was repeated over a number of those cycles, but the one that ended up before the court was payment cycle 34. And in relation to that, the contractor had applied for a net payment of just under £1.9 million. The payment due date was the 26th of February 2021. And so the 5-day period for the payment notice expired on the 3rd of March. On the 3rd of March, the employer provided what he claimed was a payment notice, but what that payment notice provided for was simply an arbitrary payment of 97p, a net payment of 97p, calculated as £1 more than had been paid up to that point, less 3% retention. And that first payment notice was sent with a covering email from the employer saying that they hadn't had time, effectively, from when the application was made, because the application wasn't received until apparently late on the afternoon of the due date, and they hadn't, in the 5 days available, they hadn't had sufficient time to do a proper assessment of that application. And so what they were doing was effectively submitting a holding payment notice for what was essentially just an arbitrary figure, but that a second payment notice would be forthcoming, and that it was the second payment notice, or the amount in the second payment notice, that would eventually be paid. And indeed, a second payment notice was issued on the 9th of March, 6 days later, for a much greater sum, £657,000, and that was the sum that was eventually paid. The amount due under that application went to adjudication. This wasn't a smash and grab adjudication, although the contractor contended that he could have brought one, but it was for what the proper value of that application was. And the adjudicator decided there was a net figure a little over what had been certified in the second payment notice, but certainly well less than the contractor had originally applied for. So the case came before the court. There were a number of issues for the court to decide, but the one that we're interested in was whether or not the approach that the contractor had adopted with the two payment notices was a valid one or not. It wasn't in dispute that the second payment notice, the one that had been issued on the 9th of March, it wasn't in dispute that was out of time. It was more than 5 days since the payment due date, which, if you remember, was the 26th of February. So it was too late. But was the first payment notice, the one issued for 97 pence on the 3rd of March, was it a valid notice or not? What the court said there was that although it was a sum stated in a payment notice, and although it purported to be a sum that the employer at that time was saying was due, it couldn't, in the light of all of the facts, realistically be contended that payment notice accurately set out what the employer genuinely considered to be due at the payment due date. It was expressly not the sum that the contractor or that the employer thought was due, and that was evidenced by the fact that it was an arbitrary figure with no real relationship to the work that had been carried out or the value of that work, but also given with the employer expressly saying that a second payment notice with the proper valuation included in it was going to be given. What the court said was that in order for a payment notice to be valid, it needed to set out the amount which the employer actually considered to be due, what the employer's genuine view of the sum due needed to be included, and including an arbitrary figure was not going to make the payment notice valid. So where does that leave us? Well, the basic takeaway message is, as I just said, that if you're going to serve a payment notice, then it must be for the sum that the payer genuinely considers to be due at the payment due date. The other lesson I think we take from it is that simply because there may be insufficient time between when an application is made and when the payment notice has to be issued, that is not a good enough reason for not serving a valid payment notice. If your processes do not allow a proper assessment to be made within 5 days of the due date, then the remedy for that is to provide in your contract to require applications to be made sooner in the payment cycle than being left to the due date itself. And the other issue, or the other lesson to take from that case is what the court also said in relation to the first payment notice was that it didn't adequately set out the basis upon which the sum, even the arbitrary sum, had been calculated, because it stated a gross valuation figure, but didn't provide any breakdown or explanation of that gross valuation figure. The reason for that, I think, was that the gross valuation figure in that first notice was simply the same as the amount in the previous month, plus the extra arbitrary £1. But that wasn't good enough. The court said if you're going to state a gross valuation figure, you need to explain how that figure has been built up in each payment notice. Begs the question in that case, I think, then, whether we're going to see, we frequently see payment notices challenged on the question of whether they're served on time or not, but are we now going to see an increase in payment notices being challenged as to whether or not they reflect what the payer genuinely believes is due? I think, for what it's worth, my view on that is that it was fairly obvious, or it was very easy to attack the payment notice in the Downs Road case, because the employer effectively said in his covering email that it wasn't what he genuinely believed was due. I think going forward, it may be more difficult to challenge payment notices on that basis unless there's clear evidence that it doesn't actually reflect what the employer genuinely believes, what the payer genuinely believes is due. But in the right set of circumstances, it is an extra avenue of attack. And certainly, if you're the giver of a payment notice, or if you're involved in advising on the giving of payment notices, the advice should always be that it should reflect the sum that is genuinely thought to be due. Okay, moving on then to the second case I wanted to look at, and this is a case on to do with everybody's favorite subject, collateral warranties. And this is a question about whether or not adjudication is available to resolve disputes under collateral warranties. Again, by way of a reminder, what the construction contract order says is that a party to a construction contract has the right to refer a dispute to adjudication, which begs the question, what is a construction contract? And the order defines construction contracts as an agreement for any of the things that are there on the slide under Article 3.1. But essentially, it's related to the carrying out of construction operations. And you'll know, if you're familiar with the order, that the order then goes through and defines a number of things that are construction operations and certain things that are excluded from being construction operations. But the basic message is that construction operations are given a very wide ambit, and essentially anything that anybody would normally think of as construction operations is very likely to be the construction operations and caught by the order. So the case that looked at that last year was this case of Toppin Holdings against Simply Construct. It is one case that has a bit of a local Northern Ireland flavour, in that the building contract, the JCT contract, was originally between Northern Ireland company Sapphire Building Services and the contractor Simply Construct, even though it was for the construction of what's described as a luxury care home in London. The works proceeded and achieved practical completion in October 2016. And then the following year, in June 2017, Sapphire stepped out of the picture and the contract was novated to Topan. And so that's why it's Topan's name that appears in the title of the case going forward. The other party of note was Abbey Healthcare. Abbey Healthcare and Topan were both part of the same group of companies. Topan, as I say, became on novation the employer under the building contract. Abbey had a lease of the premises from Topan and also operated the care home. Certain defects were identified primarily relating to fire safety issues, and works were carried out by another contractor on Topan's behalf to remedy those defects up to February of 2020. Now, Simply Construct under the building contract had an obligation to provide collateral warranties, and one of the collateral warranties it was obliged to provide was to the operator of the care home, to Abbey. They hadn't done so up to this point in the story, and it took Topan to commence specific performance proceedings under the building contract to force Simply Construct to comply with that obligation. But they eventually did and granted the collateral warranty in favour of Abbey in October of 2020. That then was followed by adjudication proceedings commenced under that warranty, where Abbey sought to claim for what it said was the loss of profit it had made whilst the remedial works were being carried out, and they wanted to recover that loss of trading profit from Simply Construct. It's worth looking, just before we get on to what the court had to say about whether or not that adjudication could be brought under the warranty. It's worth looking at what the warranty provided, just in very sort of brief terms. Those were on the slide, the three key provisions of the warranty. And what I'd draw your attention to in particular is the language that's used there, in the sense that the warranty talked not just about having performed or having carried out and completed the works and the design, but also referred to continuing to perform and continuing to carry out the obligations under the contract. So at least in terms of the wording in the warranty, it talked about both things that related to matters past, but also at least potentially future events as well. Now, the issue for the court was the collateral warranty a construction contract, and therefore was adjudication available to resolve disputes under it. And you may be familiar with this 2013 case, the Parkwood Leisure case, which was a previous case that looked at whether or not adjudication was available under collateral warranties. And what the case in Topan said was that Parkwood had established certain principles around answering this question. And it said that Parkwood had established that whilst a collateral warranty may be a construction contract, not all collateral warranties will be. And so you've got to look at the individual circumstances in each case. And it said that it had established that one pointer against a collateral warranty being a construction contract would be that all of the works had already been completed and the warranty was simply warranting a past state of affairs. But the fact that a warranty was retrospective was not a complete bar to it being a construction contract. The opposite of that was that where one party agreed to carry out construction operations, and those construction operations, or some of them, had still to be carried out, that would usually point to being a construction contract. Well, the court looked at the language and acknowledged that the language, as we saw a minute ago, both talked about things past and future performance, but focused in particular on the fact that the original works had reached practical completion some 4 years before the warranty was executed, and even the remedial works had been completed some 8 months before the warranty was executed, and said that the correct approach to be adopted is, yes, look at the language in the warranty, but construe it against the factual background of the case. And on that, based on that factual background, with the passage of time since the works had been completed, the court said that this was not a construction contract, because all it was doing was warranting a past state of affairs in relation to past works, and not future construction operations. So what we take away from that, perhaps a slightly unsatisfactory position in terms of certainty and in terms of advising upfront as to whether or not you can adjudicate under a warranty, is that some collateral warranties will be construction contracts, but not all will be, and that each warranty has to be judged on its own wording against its own factual background. The sort of general rule of thumb is that where works have already been completed, then it's unlikely to be a construction contract, but where works remain to be completed, then that's a stronger argument for saying it is a construction contract. There are a few unanswered questions arising out of that case. Probably the most significant is that I understand the case is going to appeal in the Court of Appeal, and likely to be heard sometime in the next few months. So certainly one for 2022 to kind of watch this space and see if the Court of Appeal has a different view. The issue in the meantime, though, will be whether it creates more reluctance on the part of parties giving collateral warranties to actually be prepared to do that before works are complete, or whether they hold out and only prepared to grant them once the works are complete, to avoid then also opening themselves up to potential adjudication proceedings. The other question is, certainly if certainty is a key driver here, one answer might be to include express adjudication provisions in your collateral warranty. But again, that's not something that we've seen very much up to now. And again, it's a question of whether those who are giving collateral warranties, or indeed their insurers, are going to be happy to have such provisions included in warranties that they're prepared to sign up to. Okay, so on that point, that's a couple of cases. I'll hand over to John, and he'll take us on to look at the next couple.
Thank you, Stuart. And the next couple of cases actually deal with adjudication as well. So I thought it would be useful just to draw out a couple of principles about adjudication before I go on to talk about those two cases. Believe it or not, adjudication has been with us for a quarter of a century in Northern Ireland. Our colleagues in GB got it a year earlier in 1986 through the snappily titled Housing Grants Construction and Regeneration Act. We got it in 1997 through the much more eloquently titled Construction Contracts Northern Ireland Order. But since that time, parties to a construction contract, and as Stuart says, that's a defined term in the legislation, have had a right to refer a dispute arising under that contract to adjudication. And one of the points that I'll come back to in the cases is that it's a right to refer a dispute arising under a construction contract, and not a dispute arising under construction contracts. But what then is adjudication? Well, it was brought in to try and remedy an issue which was then plaguing the construction industry, and you might say it's not got too much more improved, but it was the idea of parties being kept out of their money, where there were long-running payment disputes that had to be settled by either courts or arbitration, which could take months, if not years, to get a final decision, and all the while parties had to fund legal or other costs through those proceedings. So adjudication was designed as a way to get cash flow moving in the construction industry, and that was done on an interim basis. So you could get a speedy decision from an adjudicator within 28 days of referring a dispute to him or her. But if either party wasn't happy with that decision, then they could still go to court or arbitration to get a final decision, or they could agree something in the meantime. But it was an interim dispute resolution process that was designed to be quick and cost effective. So parties to adjudications didn't have to worry about adjudicators deciding that they had to pay another party's legal costs, and those would be borne by each party. On then to the two cases. The first I want to talk about, the case of Delta Fabrication against Watkin Jones, relates to a student accommodation project in England. There were two subcontracts entered. Watkin Jones was a main contractor, and it engaged Delta in May 19 to do cladding works, and then again in July 19 to do roofing works, both on the same project. And by July 2020, the parties had actually began administrating the payment processes for both subcontracts together. By November 2020, one final account sum had been agreed, but there was then a dispute that was referred to adjudication by Delta. Delta was successful in that adjudication. It got a decision that it was entitled to be paid money, and sought to enforce that decision by going to court. The argument then that arose in relation to the adjudication enforcement was whether or not the adjudicator had jurisdiction to make the decision that he did, and that all stemmed back to the construction contract order, or the GB equivalent, which gave the parties a right to refer a dispute to adjudication arising under a construction contract. There were two subcontracts here, albeit the one final account sum had been agreed, but that was the ground for the dispute. Watkin Jones said the decision was null and void because the adjudicator didn't have the jurisdiction to make it, because it was a dispute arising under two separate contracts. It was quite a novel argument then that Delta ran to defend that, which was that through the administration of payments under the subcontracts, Watkin Jones had issued a payment notice which related to both subcontracts, and in doing so, Delta said that Watkin Jones had accepted an offer made by Delta through one payment application to effectively amalgamate both subcontracts so that they became one. The payment notice in particular came with supporting documents, which did then differentiate between the two subcontracts. There were calculations for the amounts due under each, and the judge also looked at the parties' other conduct, which included dealing with variations under both subcontracts separately. Variations under each were given separate and distinct reference numbers, and the final account document that was issued actually referred to the above contract, which probably didn't then help Watkin Jones in relation to its argument, but the fact that the payment notice dealt with both subcontracts differently certainly did. There was a relatively high hurdle for Delta to get over in this argument. The parties were agreed that the conduct had to be unequivocal and consistent only with the parties having agreed to vary and amalgamate the contracts in this way, so that what started out as two separate subcontracts became one single subcontract. And for what it's worth, the parties had actually managed to agree that if the judge didn't side with Delta and found that there were two separate subcontracts still and two separate disputes, that the decision ought not to be enforced. Not surprisingly then, the judge came down on Watkin Jones' side and did not consider that the conduct was unequivocal and consistent. and I think that primarily came down to the payment notice itself, which contained those separate calculations for each subcontract sum, and generally the other conduct of the parties. It couldn't be said that they had acted only in a way to have one contract from that date. So I suppose the key issues to learn from that case are, if you are working under separate appointments, and it probably applies in the main to multidisciplinary practices, if you've been appointed, for example, separately as a QS and a project manager on one project, then for you to be able to refer a dispute to adjudication covering both of those, there will have to be a clear agreement, and probably something in writing between you and your client to say that going forward from the separate subcontract or appointment, that actually the parties have agreed that payments will be dealt with, and for adjudication purposes, things will be dealt with as one. Probably the same applies to disputes where you're acting on more than one project for one client. Again, if you're working under separate appointments for those separate jobs, probably worth bearing in mind that for adjudication purposes, you're likely going to have to refer disputes to adjudication separately if the worst happens and there are disputes arising under those appointments. Next case then is a Scottish case that I wanted to talk about, and it concerns a hospital project in Glasgow. The Greater Glasgow Health Board had engaged Multiplex as a main contractor, and the parties were working under an NEC 3 engineering and construction contract. NEC 3 contracts and NEC 4 contracts, for that matter, as a lot of you may already know, contain optional clauses for dispute resolution. The parties get to pick which of those two options they're going to work under. They're both start with the prefix letter W, and dispute resolution clause W2, which is quoted on the screen there, is designed to comply with the requirements of, in Northern Ireland, the Construction Contracts Order, and in GB, the Housing Grants Construction and Regeneration Act. But it's designed to comply with those adjudication requirements, and for that reason is the dispute resolution clause that is used in NEC contracts in most, if not all, of the construction projects in the UK. Certainly those that fall within the adjudication legislation. And what that clause says is that if there's a dispute under the contract, you refer to adjudication. So you appoint an adjudicator and get your decision within 4 weeks or more if the parties agree. And it's only after that, if you're still dissatisfied with that decision, you can refer it to the tribunal. And what the tribunal is usually either courts or arbitration, but it's where you go for a final resolution of your dispute if you're not happy with the interim basis on which it was decided by an adjudicator. And although this is an engineering construction contract, the same or very similar clause W2 appears in NEC 3 and NEC 4 professional services contracts and professional services short contracts. So it applies just as much to professionals as it does to contractors. The hospital project did not go well, it appeared. The health board alleged that there had been various defects in the works and that it had a claim for £72 million. It then sued Multiplex as the main contractor and others in the design team. And what we learn about those court proceedings is that they were issued shortly before the expiry of a 5-year prescriptive period. And that's Scottish terminology, but it's essentially in NI you might be more familiar with a limitation period. And that's essentially the deadline by which court proceedings have to be commenced. Otherwise, it gives a defendant a complete defence to a claim. So those proceedings that were issued by the health board were prior to an adjudication and just before the time limit by which they had to commence court proceedings was due to expire. The the health board, again, probably because of the consequences and in which it found itself, had to argue that this dispute was not one that the parties had intended for adjudication, despite what the NEC contract that they'd signed up to said. It was obviously a high value dispute. There were more than one party involved, and because it was described as complex multi-party dispute that the health board argued could lead to as many as 22 adjudications, it said that adjudication was therefore obviously inappropriate as a means of dispute resolution. Even if it was wrong about that, what the health board argued was that the proceedings should be assisted, and that, again, Scottish terminology, to allow adjudication to take place. But what that essentially meant was that the health board wanted court proceedings to be paused to allow an adjudication to take place, and that they could then be effectively started again after the adjudication. What Multiplex were arguing for was that the proceedings ought to be dismissed, which means that the health board would have to bring entirely new proceedings after an adjudication, and I assume from the judgment that that would have resulted in limitation difficulties for the health board. But what I didn't think was a particularly surprising decision, the court in Scotland decided that it didn't matter that a dispute was complex. If resolution of issues required multiple adjudications, then that is what parties had signed up to and agreed to in their NEC contract. The more perhaps novel element of the judgment came in relation to what then happened to the court proceedings. The judge decided that clause W2, which says that before you refer a dispute to the tribunal, you have to go to adjudication, was not a condition precedent to the health board starting its court proceedings. It was only a bar to the court deciding on the issues in dispute until such times as an adjudicator had decided the dispute. I'm sure that weighing on the judge's mind in making that decision was the £72 million worth of claims that the health board said it had on foot of defects in the hospital. But I suppose to finish on that tiered dispute resolution clause in W2, things to be aware of as a construction professional working under the NEC contract. Your contracts say that for resolution of disputes, your first port of call is an adjudication. That's a mandatory first step prior to referring to either court or arbitration. Adjudication, as I said at the outset, parties to it don't have to worry about an adjudicator deciding that you have to pay the other party's costs. The flip side of that is then that an adjudicator can't compensate you for the cost that you incur or the time that you spend in pursuing an adjudication. So there are likely some smaller value disputes, maybe small fees that aren't worth your while in pursuing through an adjudication. And that's something worth bearing in mind when you're deciding on your form of contract and the dispute resolution process in it. Not all standard form contracts provide for adjudication as a mandatory first step. And I suppose finally then, just to bear in mind, if you are looking at a tiered dispute resolution clause like the one we see in NEC contracts, you should be aware of the steps that you have to take before you can go to court or arbitration if that's where things end up. From a lawyer's perspective, there would likely be nothing quite as stressful as trying to get through an adjudication when you've got a looming limitation deadline, as was the case in the health board case. I'll hand over then to Rebecca at this point.
Thanks, John. Good morning, everyone. So the case I am going to discuss with you all this morning is that of Multiplex Construction Limited and Bathgate Realizations, Civil Engineering and others, which had a look at the complexity of contractual relationships in construction contracts and looks at some of the issues that could arise from a complex contractual structure such as this one. The court in this case had to consider whether an independent professional consultant who was appointed by a subcontractor owed a duty of care to the main contractor. The background to the case was Multiplex was the design and build contractor for the construction of 100 Bishopsgate, London, which was a 40-storey office block and comprised of three main buildings around an open public area. So it was a fairly substantial construction project. Multiplex engaged Bathgate as a subcontractor for the design and construction of the concrete frame of the office block. Bathgate later engaged BRM Construction, who were a specialist design and engineering consultancy to carry out part of the design works. And they also appointed RMP Associates to provide a Category 3 third-party design check, as is required by the British Standard and required under the terms of Bathgate's subcontract with Multiplex. Bathgate then went into administration and an alternative subcontractor was engaged. The new subcontractor subsequently discovered defects in the works, despite the checks which RMP had already completed. So the defects had to be rectified then before any works continued, and Multiplex then commenced a claim for over £12 million against Bathgate, BRM and RMP's insurer, who was Argo, because RMP had actually gone into administration. The 12 million claim included money for remedial works, delay, disruption, and then the consequential losses. Despite there being no contract and no direct contractual relationship between Multiplex and RMP, Multiplex alleged that RMP owed it certain duties of care and obligations in respect of the check and certificates issued by RMP. Multiplex's case against RMP centred on the argument that RMP owed a duty of care arising from an assumption of responsibility. It also claimed that the certificates which were issued by RMP contained warranties to Multiplex which had been breached. So the court heard a trial of the preliminary issues which concerned the legal relationship between Multiplex and RMP. This trial lasted for 3 days, during which time Multiplex had to prove that RMP firstly did owe such duties or provide warranties directly to Multiplex. And then if they were unable to prove this, then their claim against Argo would ultimately fail. So there were 2 issues to be determined by the court. The first one being, did RMP owe any duties and or obligations to Multiplex in respect of the checks and the design certificates, which were provided by RMP to Bathgate? And then secondly, did RMP provide warranties to Multiplex? So after hearing submissions from all the parties, the judge came to the conclusion that RMP did not owe any duties or obligations to Multiplex in respect of the check design certificates, nor did it provide warranties to Multiplex. The judge gave careful consideration to the facts of the case when making this decision and held that RMP did not assume responsibility to Multiplex for the statements which were contained within the certificates for a number of reasons. The court identified 15 reasons for why it reached the decision it did. I'll not go into them all, but probably the main ones to consider. Firstly, they found that Bathgate had full design responsibility for the subcontract works under the subcontract with Multiplex. This included the responsibility for the design of the works, which were, of course, found to be defective. Secondly, then, there was no direct contractual link between RMP and Multiplex in relation to the check or at all. The purpose of the check was so that Bathgate could comply with its own contractual obligations under the subcontract. The third point then was that Multiplex was not actually involved in the instruction of RMP, so it didn't know, what documents had been provided to RMP, didn't know under what terms RMP had been engaged, and no services were provided directly to Multiplex by RMP. And then the fourth point I want to discuss was this project had a large number of parties and a detailed contractual structure, including the main contract and various subcontracts. The relationship between Bathgate and RMP was entirely separate from this. And the judge stated that if he was to find that there was an assumption of responsibility on the part of RMP direct to Multiplex, then this would indeed short circuit the contractual relations. In addition to the 4 reasons, the judge also held that there was nothing on the face of the certificates to constitute a warranty to Multiplex. The judge said that it would be difficult to see, based on the facts, how RMP had given any warranty to Multiplex at all. So lessons to learn then from that case. So everyone will know that it's often the case in large construction projects such as this one, that there would be a number of parties and a complex contractual structure. This case highlighted that the court would appear to be reluctant to impose a duty of care in circumstances where the parties have chosen not to establish a contractual relationship with each other. If a main contractor intended to be able to pursue a subcontractor for defective design or workmanship, then the appropriate mechanisms would need to be put in place to allow it to do so. So that may include, specific provisions being included in a subcontract, which would require subcontractors to procure collateral warranties or third-party rights in favour of the main contractor. The judgment as well provides some valuable reassurance to independent design checkers or third parties, and as was in this case, their insurers, that they wouldn't necessarily assume responsibility to parties with whom they don't have a direct contractual link in order to prevent economic loss. So the court recognised here that if they had found differently, this would have caused potentially serious consequences within both the insurance and the construction industries. So I'll now hand you over to Gavin, who's going to discuss our last case of the morning.
Thanks, Rebecca. So good morning. I'm going to talk about a case that involved whether a purported verbal agreement was binding on the parties in question or not. The case was a recent TCC case in which judgment was delivered on the 12th of November 2021. The claimant, Mansion Place Limited, was a property developer which engaged the defendant, a contractor, Fox Industrial Services Limited, to refurbish and extend student accommodation in Nottingham. The contract was an amended JCT design and build contract, which included liquidated damages provisions in the event of late completion. There were delays in the performance of the works under the contract. Fox, however, claimed that these delays were due to the COVID-19 pandemic and the national lockdown, and also to a greater extent due to the Mansion's failure to give timely possession of the site and the clear of students to allow Fox to progress the works. Mansion denied Fox's claims, and Mansion's case was that Fox had failed to progress the works and to commit sufficient labour and resources to the works. On the 22nd of October 2020, Fox issued an interim payment application which was duly certified at $367,000. Mansion served a pay less notice and a number of notices of intention to deduct LADs. However, prior to issuing the interim application, a conversation had taken place between the parties on the 14th of October 2020. The conversation that had taken place on the 14th of October was between a director of Mansion, Mr. Ramanathan, and a director of Fox, Mr. Kite. Both directors were driving and using hands-free during the call, so neither took a note of what was said, nor were any written notes of the conversation taken immediately afterwards. Fox was of the understanding that during the call, Mr. Ramanathan had specifically agreed that Mansion and Fox would each drop their respective claims for LADs and loss and expense. Mr. Ramanathan disputed that any such agreement had been made, his recollection of the conversation being that he had encouraged Fox to progress with the works and had suggested that Mansion would seek to resolve any outstanding issues after the works were completed. On the basis of this dispute, the matter was referred to adjudication, and the adjudicator decided in Fox's favour that there had been a binding agreement reached during the call on the 14th of October, and that Mansion was to pay Fox the sum of just over $524,000. So, unsurprisingly, Mansion disagreed with the adjudicator's decision and commenced court proceedings seeking repayment of the sums paid out on foot of the adjudicator's decision. The case was brought before the TCC, with Mansion seeking a declaration that no binding agreement was made as a result of the conversation on the 14th of October. However, the court preferred Fox's evidence and found that a binding agreement had been reached during the call on the 14th of October, by which Mansion had abandoned its right to require payment of liquidated damages for delay in exchange for Fox abandoning its loss and expense claim. The judge was satisfied that the agreement was a final abandonment of those rights. So how did the court come to reach its decision? Both parties agreed that there was a conversation after 6 p.m. on the 14th of October 2020, during which both directors were driving and using hands-free. The parties also agreed that the conversation was short and pleasant. However, other than that, the parties' recollection of the conversation largely differed. Both parties provided documentation alleged to support their version of events, including emails and letters. The court also had the benefit of witness evidence from both directors. Mr. Ramanathan's version was that Fox were encouraged to progress the works and to resolve issues after completion. Mr. Kite's recollection was that it was specifically agreed by way of a gentleman's agreement that the parties would drop their respective claims for LADs and loss and expense. The court sided with Fox and decided that the parties had reached a binding agreement on the 14th of October, in terms of which Mansion had agreed to a final abandonment of its right to claim LADs. The court found that Fox's recollection was more reliable than Mansion's, and Fox's version was better supported by subsequent emails and documents. The court looked at the witnesses' evidence through the prism of contemporaneous documents of their subsequent actions, of those events which are clearly accepted or clearly demonstrated to have happened, and of the inherent likelihood. So moving on as to what were the factors that swayed the court in the context of the brief conversation, in respect of which both parties' recollection was so markedly different. The court had regard to the demeanour of the witnesses and the impression formed in the witness box, but took care not to place undue weight on that impression. As such, the reliability of the witnesses' recollection of the phone call was assessed in the light of contemporaneous documentation and also the parties' conduct after the call. Fox had set out its case in a letter dated the 16th of November 2020 that there had been agreement reached on the 14th of October for mutual abandonment of the claims, in that Mansion would not seek to levy LADs and Fox would drop its claim for loss and expense. Mansion replied the same day, but did not in its email of reply or in an email sent the next day suggest that Fox's account of what had been said and or agreed on the 14th of October was wrong. This appears to have been a deciding factor both in the adjudication and in the case before the TCC. The adjudicator regarded this failure to deny the agreement as telling. Mansion tried to explain the failure to deny the agreement in that Mansion said it didn't want to disagree and antagonize Fox at that point. However, the judge found this explanation as unpersuasive, particularly as the party's position had become entrenched by that stage, for example, by the service of Mansion of its pay less notices in relation to Fox's interim application. So finally, moving on to the lessons to learn here. As was the case, the court noted that where there was a short conversation with no contemporaneous record, a court could rarely make a finding as to the precise words. And here, the judge took his task to be to consider whether they could make a finding as to the gist of the conversation on the balance of probabilities. The judge was satisfied that there was an exchange in the context of both parties wishing to move forward to a rapid completion of the project, in which Mansion agreed to drop its potential claim for LADs in return for Fox agreeing it would not claim loss and expense consequent upon an extension of time in relation to the works. However, this situation could have been avoided and highlights the importance of the party following up a telephone conversation with a note setting out what was discussed and agreed. Whilst the circumstances of the agreement between Mansion and Fox were particular to this case, it illustrates the point that claims for sums in excess of £500,000 could be settled during a hands-free conversation, meaning that agreements don't necessarily need to be signed or to be in writing to be binding and enforceable. The case serves as a timely reminder of the importance of making notes during or immediately after oral negotiations and confirming what was agreed with the other party, either by email or by way of a follow-up letter. By failing to commit any agreement to writing, this may result in a costly dispute down the line regarding what, if anything, was agreed and entail an extensive and troublesome trawl for other evidence supporting one or the other party's position at a later date. So that leads us to the end of our discussion as to the various cases, and I think possibly may have run over slightly, but we still have a couple of minutes just in relation to questions, if there's any that have come through, David.
Thank you very much, Gavin. Thank you to all the speakers. They're all very, very good. We have a few questions in here, and I'll just skip through them here quickly. First one's for John. John mentioned that the multiplex case was in Scotland. Do you think that a court in Northern Ireland would make the same decision, John?
Thanks, David. Certainly I can see why the Scottish court was keen to make the decision that it did, with £72 million bill for defects in a hospital. It'll be a brave judge that effectively bring an end to any claims to try and recover that money by saying that the health board couldn't bring those proceedings without first going to adjudication. I suppose do I think a court in Northern Ireland will make the same decision? The wording in the NEC contract, clause W2, says that a dispute cannot be referred to the tribunal. And the Scottish court decided that meant that the court couldn't make a decision on the issues in dispute. I'm not sure that's the most natural meaning to the wording in clause W2. To refer to a court, to my mind, does imply that you're bringing the matter to court. So I think it's reasonably arguable that is essentially starting the court proceedings, which would then cause difficulties with limitation in that health board case. But for Northern Ireland court, certainly it's going to be persuaded by the Scottish court's decision, but there's scope there that I think a different decision could be made, and actually court here could require parties to have adjudicated before court proceedings are commenced. But so the overarching point, if you know that there's a deadline looming, make sure that you complete any mandatory steps before that deadline expires. So I assume those disputes in relation to defects were known for a number of months, if not years, and some planning could make sure that appropriate steps are taken to avoid the stressful wait to see whether a court here would make a different decision or not.
Okay, thank you very much, John. The next question is for Stuart. Stuart, in the light of the Topan case, do you think that we are likely to see an increase in adjudications brought under collateral warranties, and how might that affect parties' willingness to provide warranties?
Yeah, I mean, I guess the jury's out on that. Certainly experience up to now has been that people seeking to adjudicate under collateral warranties has been much less common than adjudications under underlying building contracts. It may be that the Topan case really sort of draws people's attention to the fact that adjudication under a warranty is a possibility. I have to think, though, that there's probably a couple of things that are would probably dissuade people from adjudicating under warranties. One is given in any given warranty or any given set of circumstances, there's going to be a degree of uncertainty as to whether or not adjudication does actually apply, and therefore, if you go to adjudication, whether you'll end up with an enforceable decision. The other issue is the types of claims that people bring under warranties. They're not the straightforward payment claims that you get under a building contract that lend themselves best to adjudication. They tend to be around defective work and alleged professional negligence. And those sorts of claims are maybe less well suited to adjudication. But the caveat to that is, I would say that case is going to the Court of Appeal. If the Court of Appeal comes back strongly saying, yes, you can adjudicate under collateral warranties, well, maybe that will be a bit of a green light to those who want to go down that route.
Okay, thank you very much. That's us really for questions and time, really. We said we'd try and finish up by 12 o'clock, and that's where we're at this stage. I think the speakers did very well. Thank you very much indeed for all your input. Particularly interesting about the adjudication over the hands-free conversation in the car that's a lesson to all of us, I think, definitely. So, as I say to everyone, thank you to Stuart, to Galvin, John, and Rebecca, and thank you very much for joining us this morning.
Thank you.
Goodbye now.
Appreciate
Thank
it.
you.
Everyone.
Thank you.
Thank you. Thanks.